Okay. Thank you very much for your patience. Staff have advised me that the item, which was 71 Grace Street, and this is item 42. Item 42, 71 Grace Street, which the committee had deferred due to the absence of the applicant or the owner. We have since, so apparently the applicant had been frantically trying to connect with staff and get on. There was a bit of a miscommunication with the registration. So he will be joining us. So although we've made a decision on the application that it be deferred, would the committee be open to reopening this matter now that we have the applicant available? And I believe the reason for deferral was the fact that the applicant was not available to answer the question. So if the committee has an appetite to open the matter, may I have a motion on reopening item 42, which is 71 Gray Street? Member Saeed.
Madam Chair, it's quite acceptable. I am willing to support that. So I will move the motion for reopening of discussions on application number 42.
Okay, all right. May I have a seconder to this motion? Member McKay. All in favor of this motion? All opposed? Okay, so motion is carried. Application for 71 Grace Street will be reopened and discussed at the hearing today.
Just want to clarify, was Member Taylor in opposition?
Yes,
Okay, thank you.
so although the motion has passed. Okay, so we are now going to, and what's the name of this applicant? Bruno? Okay. Okay. Bruno, are you with us?
Yes, I am. I've been patiently waiting for this moment for 4.5 hours.
Oh,
If he doesn't mind waiting 30 more seconds. Sorry, Madam Chair, are we on item 41 then, Oak Ridge Drive?
no. We have gone back to item 42.
We're on Gray Street. Okay, thank you.
Yep.
Yes, good evening, everybody, and through you, Madam Chair. Yeah, these are if any of the committee members have any questions or if they want a brief presentation. I believe there was a question in regards the forestry. I believe that the question will stand still.
That's correct. So we were hoping that you would be available to answer the question. We have a memo from Urban Forestry recommending refusal of the variance, and we typically do not make decisions on an application where there are refusals or recommendations of refusals from other departments. And hence, we had deferred the application to allow you to come back to the committee. But since you're here, so I would take your offer and ask the committee members any questions for Bruno at this time. I know, Member Macaulay, you had some questions, or at least you had flagged this fact.
Yes. I thought we were on item number 41 as well, so I need a minute to get to item number 40.
No problem.
Perhaps the applicant can give us a very quick presentation as to what his proposal is. It's one consent and two variances.
Yes, correct. So if I may, actually my client about a year and so ago had a previous application, or actually pretty much same application, but they were actually looking for a severance and actually create 3 lots. Through the process of submitting to committee and having here to staff planning, they were not in favor of 3, but they were in favor of doing 2 lots. So we proceeded with that situation. So staff was in our favor. We had drawings submitted at first, and we had comments from forestry. So there were a few trees that were actually being affected, and we try to improve the situation. And if you see, there are actually drawings and there is a precedent drawings. So we had a second set of drawings that we submit lately, to about maybe 3 weeks ago, and we actually switched the driveways from the inside to the outside, actually to the inside, and we actually had two more trees that they are not affected. So the two trees in question, one is in good condition, one is in fair condition. Actually, the tree in fair condition, we have letters from the neighbors that they really don't want that tree because it's literally destroying their backyard. So talking to Mark, the manager from forestry, he was in agreement and we proposed a 3-to-1 replanting. So we are planting six new trees, six trees. Sorry, I thought I heard someone. So we are proposing six new trees in lieu of the two trees that we're gonna cut down. And again, he said, like, Bruno, this is sort of like a tick on the box. There is nothing that I can do. I cannot support because it's our policy. When you take a mature tree, we have to refuse the application. Although he was somehow condescending and in favor of us doing the replanting.
Okay. All right. Member Macaulay, does that help you?
I guess that helps in the discussion of the trees. Does he want to address what we're going to give him approval for? He's asking for a consent and variance applications.
Yes, correct. So, if I might talk about the consent. So again, we are proposing two lots when initially we were proposing three. So being two lots goes more within the neighborhood. So in a nutshell, along Grace Street, and this coming to the variances, along Grace Street, the lots are 342 meters, and along Bellamy Road, they are 266 meters. So we think that we are not within the required lot size, but we are way bigger if we compare to the adjacent neighbors. Um, in terms of the second variance, we are proposing 33.9 as lot coverage, while we are 33% allowed. So this is like a 1% more. We don't feel that it's a major variance. This is very small in kind. And the third variance that you have for both proposed lots, it's actually the rear yard setback. It's 7.5, which is the requirement from the bylaw, and we have it 6.5. So it's so we can accommodate and create actually a couple balanced new homes.
Okay, thank you. I see that certainly what you have is wide lots but shallow. So the rear yard setback is something that you're almost forced to have. I have no questions.
Absolutely, that's a great point because there is no way we can. Again, it's almost impossible to eliminate that one.
Okay. Thank you.
Thank you.
Thank you, Bruno. Any questions for Bruno? I see none, and there are no registered speakers. So if there are no further questions for Bruno, can we take the matter into committee and make a motion on it? So we're dealing with a consent application, and then we have the, no, this is a consent application only. No, there are two minor variances, sorry, two minor variances. Member Taylor.
Yes, Madam Chair, I'm not prepared to make a motion on this. I just wanted to explain my not supporting the motion to defer, because in my mind, we as a group have to deal with the fact that we have a comment from Urban Forestry recommending to us that we deny the application. and I'm just at a loss right now, and I'd like to hear from others, how we deal with or reconcile that. Oftentimes, urban forestry will say, we recommend denial. However, if the committee doesn't want to do that, they'll give us some options like conditions 1, 2, 3, whatever like that. But in this case, it's an emphatic deny. So that's my problem. What do we do with that reality?
So I think, Don,
So
if I,
I'd like to hear other views on that.
okay, if I can take a cut at it, so the way I see it is you have the applications before you, and Urban Forestry is a commenting agency. They provide their comments, right? We're dealing with a consent application. So first of all, we got to distinguish between the two applications. We have a consent application and then we have a minor variance application, okay? Now, you have to consider all the criteria, run all the tests. So criteria under the Planning Act for consent and the tests for the minor variance application. And as part of doing that, you take all these comments and feedback into consideration to make your decision. So if in your opinion, that is a strong, or that opinion matters, or that feedback matters to you in your decision making, or to inform your decision, you're entitled to make a decision on that basis. So it's like any other agency or department that provides comment and provides their feedback.
Well, if no one else has any questions or comments, I'm prepared to make a motion.
I will check with others. Member Macaulay.
I have a question. Again, I don't have everything here in front of me. We received those comments from Urban Forestry. Have we received a more updated report from them? Because the applicant is saying that he's had meetings with them.
No. The applicant's saying he had meetings, but it didn't result into anything other than what you see before you today.
Okay, I misunderstood that the applicant was going to provide 6 trees versus the ability to take down 2 of them.
No, that was an option he was discussing with the supervisor of urban forestry, but the supervisor
And we
maintained.
have nothing.
No, we don't. This is the memo from April 16, so that is the latest memo. Remember, again, as I said, this is one consideration, but you have to look at, remember, the tests and the criteria are to be at the forefront of any decision making. Trees, absolutely, they're important. And we have policies around it, and the city has policies around it, but when it comes to the decision on the applications, you have to go with the criteria of the Planning Act.
Yes. And I think in this case, because we have a consent application, we have an option to state that one of the conditions of approval of the consent application is approval from urban forestry regarding the provision of trees on both of these lots. If they don't fulfill that condition, the consent will fail. But it doesn't mean that if they can satisfy urban forestry, we don't have to refuse the consent at this time.
The problem I
we
see
can
it.
change our.
So staff has highlighted a portion on the screen. Should the committee approve this application in the knowledge that there are removals or injuries will be required, urban forestry would then issue the tree removal injury permit subject to our authority under the tree bylaw.
Madam Chair, I am also looking at one of the advisory comments of the urban forestry memos, the advisory comments number 1, which reads as any application to injure or to remove a city-owned tree may be denied by urban forestry, regardless of committee of adjustment approval. So that means if even if we approve a case and we say, okay, the tree could be removed, but when it's go to the urban forestry and they don't agree, they can make any decision regardless the approval of the committee of adjustment.
They can make a decision on the trees and matters under their jurisdiction, right? So that is a risk that the applicant will have to bear. Should the committee approve it, they have to get clearance from urban forestry. And if urban forestry does not grant them the necessary approvals or the green signal, then that is between the applicant and urban forestry to resolve. What we have before us, urban forestry is one criteria of many other criteria that you have to consider in making a decision on an application. And as pointed out in that particular memo from urban forestry, that should that happen, should the committee approve it, the urban forestry would then issue the tree removal injury permit subject to their authority and whatever that authority constitutes. Okay?
Madam Chair, I think we're at the place that either we approve the consent application based on the planning grounds and subject to a condition of approval from urban forestry, similar to approvals that we ask for from engineering planning or any other agency, or we refuse the application and ask the applicant to go back to urban forestry and get a revised letter from them if he wishes to proceed. I'd be
Staff,
inclined at this stage, knowing that we have a consent application, that it is appropriate to add conditions, that we add that condition that the applicant has to fulfill the requirements of the
yeah,
urban forestry to their satisfaction.
okay, so here's the
And
thing.
let them proceed to try to do that.
Here's the thing, Member Macaulay, we can certainly put in conditions, but I want to make sure that that from a staff level, it's implementable and enforceable. So I'm going to turn it over to Colin. Colin, could you shed some light on the proposition?
Through the chair, there's actually a third option that the committee may wish to consider based on the highlighted aspect, the highlighted portion, that text that was in the urban forestry memo, is that the committee could approve the application subject to just ECS conditions, period. Because the urban forestry conditions and the urban forestry comments, they have their own process for that.
Yeah. So it's thank you, Colin, for expanding on that. So any tree removal, any tree planting, well, tree removal or injury requires approval from urban forestry, right? So to Colin's point, which is basically his sort of advice or technical advice to us, is that even if we were to not include, which in this case it is possible because there is no condition from urban forestry, right? So if we approve the application subject to conditions of engineering, the applicant would have to go through the necessary process to obtain approvals or permits from the urban forestry, and then manage or deal with urban forestry at that stage. Okay? I hope that helps. That is, again, I'm going to repeat, one comment, one agency providing their feedback to inform our decision. Yes, Member Macaulay.
If I could have a bit more clarification, if we don't put in a condition of approval from urban forestry as approval of the consent application,
They would still have to get.
I'm not sure. I'd like to hear from staff as to how that approval has to be obtained.
Through the chair, in terms of In terms of building permit, the building permit like there is a separate process. It's a separate bylaw, the private tree bylaw that's administered. It's outside. It's typically outside of the committee of adjustment process, but we do circulate to urban forestry so that they can recommend conditions, and it really is up to the committee whether they wish to impose those conditions or not. But through the building permit process, correct me if I'm wrong, Katrine, in terms of the tree permit process, that is a separate process that will be administered by urban forestry outside of the committee of adjustment process through the building permit process.
Yes, Colin, you are correct. There are two bylaws that regulate, one for street trees and the other one for private trees. And they meaning applicants or developers would have to undergo and undertake whatever necessary measures that is outlined in the bylaw and through the application process and work with urban forestry to resolve any issues.
Thank you,
That is
Katrine.
wrong. Okay. Tree replacements.
Yeah. Thank you, staff, for your advice on
Thank
this.
you.
I would just like to say that Member Macaulay, think of a building permit process only, which doesn't, or development that doesn't have to come to the Committee of Adjustment. They're still subject to the two bylaws. Every property in the city is subject to the bylaw, the private tree bylaw and the public tree bylaw. So it's not just in the committee's jurisdiction. There are other authorities and jurisdictions that would require those bylaws to be, or the bylaw itself would have to be implemented and enforced. So any permit, if required, shall go through its course of action through those processes, such as the one that Katrine just described, for example, the building permit process. Okay?
Yes, I understand, and thank you, Katrine, for clarifying that. I think I still prefer it to go through the consent process because according to what you are saying correctly, the tree bylaw doesn't come into place until, or doesn't come into play in this case, until such time as the applicant goes for a building permit. When he's going for his building permit, he's probably already created the lots. He may have made substantial changes to the lots, including cutting down trees.
But he can't cut
And,
down, but this is the thing, Member
so
Macaulay, he
the
cannot cut
remedy-
down the tree without getting the permit. This is the point I'm trying to make. He cannot cut down that tree without getting a permit. All properties in the city of Toronto are subject to that bylaw. So I cannot cut a tree on my property that meets certain criteria. So any tree removal in the city requires a permit from the city, and that would have to be obtained, regardless of we issue the consent regardless of we approve the consent or do not approve the consent. Anyone chooses to remove a tree needs a permit.
All right, I will send corrected. I only hope that all citizens follow that.
I would like to think that too and hope so too. Okay, Member McKay.
We don't have any, community planning staff report here. I'm just wondering if the members want to weigh in because I'm having some difficulty about sort of the planning merits of this particular severance and as to whether the frontage in the area are appropriate. And as I say, we're kind of missing, I think, missing planning opinion evidence on this.
Staff, could you please advise?
Through the chair, with all committee of adjustment applications, they are circulated to various divisions, including, in all cases, community planning. Community planning were circulated these applications. They had no comment. This actually originally, as the applicant mentioned, it was originally a 3-lot a 3-lot application, three lots. They revised it to 2 lots only. It has gone through an extensive community planning process.
Member Macaulay?
When I look at the consent application on its merits and the creation of two lots here, if you take a look at the subject property and the lots that are in that area, you can see that this is a lot that is a little different from everything else. It's probably the only one on the south side of Grace Street, but there is a house on it with sufficient side rear yards. And the lots on the north side of Grace Street, if this lot was created into two, would be of similar size. So from my perspective, I think the size and the shape of the lots being proposed here are satisfactory. They are in keeping with what you see in the area and is of sufficient size to accommodate a house or two houses in this case. So I don't personally have any problems recommending the consent. I don't think it cuts any of the neighborhood provisions. Um, and
Okay.
I believe that servicing can be provided. I think the only issue we have here is the issue of the trees
Okay.
and whether we want to proceed with that or not.
Okay, thank you, Member Macaulay. I think we've spent quite a good time on this application. We have more to go through. So I would now recommend, suggest that the committee start thinking of the motion at this time, please. Member Taylor.
I'm prepared to make a motion, and I thank everyone for delving into the issue that I raised and some time ago determined that, Madam Chair, you're quite correct. Urban forestry is only one of many considerations that we have to deal with. And I'm satisfied that based on the preponderance of the evidence here, that the first of all, the consent is quite appropriate and reasonable development for this area. And I move approval of the consent subject to urban and, ECS conditions plus standard conditions of consent. And on the minor variances, I find them to be in keeping with the 4 tests under the Planning Act, and I move approval of those as well.
Thank you, Member Taylor. May I have a seconder, please? Member McKay.
Madam Chair, I am prepared to second the approval of that motion.
Okay, thank you, sir. All in favor of this motion? All opposed? Okay, members say the opposes the motion, but the motion's carried and the applications for the consent and the associated minor variances have been approved, subject to conditions of engineering services and standard conditions of consent. Thank you very much. Okay, so we had reopened this item and we have made a decision on it. I now go back to the order of the agenda that we were at. So now we go back to item 41. Item 41 is 74 and 78 Oak Ridge Drive. And we have Peter Jerusik with us.
Hello, committee.
Okay, thank you. And I want to check Marina Murphy. All right, Marina Murphy is
Yes,
also
I'm
with
here.
us. Thank you, ma'am. Just stay with us for a bit. So Peter, we have your application. Do you want to, do you have any comments at this time, or do you want to go through the questions?
Just a brief statement. These houses, all three, this has been severed, have had certificate officials. My client, just in his lack of knowledge and his lawyer's lack of knowledge, I guess, the 2 years had expired when they finished the houses and when they were trying to sell it. That's when it came up that the pins weren't registered, and when his lawyer started to try to register it, he realized that the 2 years has expired. That's why we're back before the committee to just get the severances again, so they can register the houses. All three houses are completed and built, and have even been inspected, and they're just waiting for exterior inspection for grading. That's it.
So just for everyone to understand, all conditions of consent were satisfied, everything was done, permits were obtained, the buildings are in place. It was just sort of the last nail that was missed, correct? For the lack of a better term. And that's why you're before the
That's correct.
committee.
Yeah.
Okay.
The lawyer forgot to register the pins, but within the 2 year mark.
Okay, and that is, in my opinion, very administrative and sort of legal admin in nature. Okay, all right. Members of the committee, any questions for Peter Jerusik? No questions? Okay, all right. We will now move to Marina Murphy.
Hi, thank you for having me on. I am a neighbor of this development, and I'm concerned about the fact that the proposal back when 72, 74, and 76 were built, that they had gone to the OMB, and the owner was denied because he had originally requested 5 homes to be on the one lot. That proposal was denied at OMB, and approval was given for 3. And those 3 houses are in fact built right now, and I'm sure that they are coming to completion. What they're asking for now is to borrow some land from 78 that the owner also owns and is renting out right now, and wants to borrow some land from that property. And I suspect what's going to happen is that they're looking for the rezoning so that 2 more homes can be built on property currently a single family dwelling on 78. So I'm very concerned because Oak Ridge Drive is under siege, and I'm not sure if you guys are aware of various applications for severing of lots that have gone on in and around my home and on this section of Oak Ridge. But what's happened here is that we are setting a very dangerous precedent because these homes are being severed and monster homes are being erected. And in the last 5 years, in the immediate area, and when I say immediate, I mean like across the street from me, 2 doors down on my left and 2 doors down on my right, all these properties have been done. And so it's very concerning, and I don't understand why they're asking for the rezoning unless, of course, a subsequent application is going to be submitted to sever the property, and we will be under construction once again with monster homes. And incidentally, right next door to me just sold to another builder, and it is a double lot, and I suspect that the same application for number 80 will be crossing your desks shortly. So I can also comment on the trees because here in South Scarborough, in this area that we live in, has a very, very heavy tree canopy. And when the lots across the street, or the lot across the street, was severed, number 85 into 85 and 87, the builder took down many trees on a weekend, and the trees have not been replaced. I know that Mark Ventresco tries his best to monitor these, but I do know that many trees, probably upwards of 6 or 7, were removed to build at 85 and 87. And I know that that kind of practice happens because I watch it, because I live here. And I'm very concerned, and I've been waiting on online here for 4 hours to express my concern about my neighborhood and what's been happening.
Okay, Thank you, Marina. I appreciate you taking the time and waiting to speak with us. I really appreciate that. So just want to clarify, there's no rezoning being proposed with this application. This is a consent application that was approved by the board a few years ago, and the consent has lapsed because as you must know that there are several conditions for consent to be fulfilled and satisfied over the course of 1 year and 2 years. So the applicant satisfied all the conditions except one last one, which is strictly technical and administrative in nature, which was the filing of the PIN. So that did not
What does that
occur.
mean? I'm sorry. What's the filing of a
So,
PIN?
so basically what it is you have to go to the land registry office and say, here's the PIN that we're trying. It's a very legal thing. I'm not a lawyer, so I can't speak, but I know it's highly technical and legal in nature. It is basically, it's got to do with the land title and the PIN numbers associated with it that have to get registered on their particular parcel of land. Okay?
And they're borrowing, though, a
No.
piece
So
from
here's
78.
yeah, so here's what I'm a little confused about. I have checked, double checked, and triple checked with staff. They have confirmed that there's no change to this application that is before us today. There's no difference between this application and what was before the board a couple of years ago, or 3 years ago, 4 years ago. There's no change. You're perhaps looking at a reference plan that is showing a part on it, and that may be kind of throwing you off a bit. And we can certainly get clarification from the applicant as to why the configuration of the reference plan is like that. But there's absolutely no lot addition or lot borrowing or additional lot being created through this application. It'll remain the same application as it was before. Okay? I will give you a moment, Member
Okay.
Macaulay, just bear with me. So I just want to get through Marina.
Mm-hmm.
So I just want to,
And so
yeah.
in the property address that they give, 74 and 78 Oak Ridge Drive, 78 is not a part of the 3 homes that have been erected. 72, 74, and 76 are the new homes, and 78 is as it was before.
Correct. And sometimes readdressing takes time to happen. And I think the addressing that is being shown is being pulled of the, I guess, impact assessment data or something, and that's still showing the old address. But again, staff is here and they can confirm and reconfirm that there's no change to the application. So addressing has nothing to do with the lots. Once the lots will be registered, they will be assigned an address. Staff has some clarification. Staff, please go ahead.
Through the chair, I'm just going to share my screen, and this is the registered draft reference plan, which was deposited, meaning it was registered in the Land Registry Office in August of 2017. So this is how long ago the applicant has tried to clear some of the conditions, including the depositing of the reference plan. Part 4 will be consolidated with 78 Oak Ridge Drive. And the rest of the parcels, parts 1, 2, and part 3 will house the recently constructed or under construction of the detached dwellings. Hopefully that clarifies the purpose of this application, which is in line with the former OMB decisions.
Okay, Marina, does that help you further?
No, it doesn't, because it is legal jargon from what I understood, that back in 2016, what I understood was that the OMB had denied or rejected the application, and that the owner failed to apply
Applicant,
within 1 year. That it's 5 years now since this has gone through. And
Okay.
I'm assuming that they're ready to go now because the 3 homes are and have sold signs on them that they're ready to move on the other parcel of land,
Okay,
which has
no,
a single-family dwelling on it.
okay, fair enough. Marina, I think at this time I would want to move over to the applicant because my role was here to clarify and confirm that there were no changes to the application that was before the committee. When it starts to get into more details, that's when I would like to defer to the applicant. So if you do not have any further comments, I would like to move to the applicant to provide a response. Okay,
Very good, thank you.
thank you. So can we have Peter back, please? All
Hello,
right,
I'm
Peter.
back. Okay, in terms of the lot severances, the original one was for both lots to be divided into five. At the OMB, the decision came down, they permitted only those 3 lots that we've built those houses on. That was permitted at the OMB, was not denied at the OMB, it was permitted at the OMB to eliminate 2 of the lots, which are lots 78 Oak Ridge, and to permit the 3. Now, the original plan did have that part 4 taken and given to 78, and that is how we proceeded. That's how it was approved at the OMB. And with this application, it's still the same thing. That portion, part 4, is being given to the owner of the property on his 78 Oak Ridge Drive.
So staff is putting up the reference plan on the screen, so perhaps, Peter, you could sort of identify the parts.
Sure thing.
I appreciate it's difficult for general public to understand the legalese, so if you can help understand, that would be great.
So this lot here is 74. Parts 1, 2, 3, and 4 are make 74 Oak Ridge Drive. The new houses, what was granted by the OMB was parts 1, 2, and 3 to allow 3 new lots, and part 4 was to be added to lot 7 to 78 Oak Ridge Drive. That was what was granted at the OMB, and that is what we are requesting again right now. We had not changed anything from what was granted from the OMB.
Okay, well, thank you, Peter Jurusik. I think that was quite clear, and I'm confident with this information. Now, I think the neighbors' concerns hopefully have been addressed, or at least tried. We tried our best to answer the questions. At this point, members of the committee, any questions for Peter? I see none. Okay. If there are no further comments or questions, can we take the matter into committee? Member Macaulay?
We can take the matter into committee. I don't know whether staff can clarify a question that I have of staff.
What's that question?
Question actually deals with that part 4 and the consent application that was granted by the OMB. We have a copy of the decision, with it's not a complete copy. In the decision, there should be a list of conditions, and one of the conditions that I would be looking for, which would satisfy the neighbor, is that part 4 is to be conveyed to the parcel adjacent. So although it is created as a part, it's only created as a part with the statement that it has to be conveyed to the adjacent lands. That's what I was looking for. The decision just is the first part of the OMB decision, and it doesn't list any of the conditions.
There is a schedule. If you look at the PL 160249, the OMB decision, there is a schedule of conditions attached there. There's an exhibit.
Okay. Can we quickly find that?
It's
that
page
statement then?
1321 of the PDF.
it isn't clear, because they say it's in accordance with the exhibit.
So,
I
so
think we just have to,
yeah, member
I think
Macaulay
we
at
just have to go on that basis.
Well, there's I think further down there's more discussion. I mean, if you look at page 1323, it shows a site plan, and it shows the three lots, the three houses, and part four transfer to 78 Oak Ridges. There you go, right there. See that part four, and that appears to be part of 78 Oak Ridge, and because it shows the setback and everything.
All right, that's what I would expect that we would be able to see.
Yeah, so that is part of the decision, and it's in this exhibit with the decision. Okay, so I think we need to move on. I think we've spent quite a bit of time on understanding this, and especially when there's no change to the application. So at this time, I would request for a motion. Member Taylor.
Madam Chair, this is an administrative technical application. The merits were determined by the OMB in September 2016, and I move for approval without conditions.
Okay, may I have a seconder, please? Member Said?
Thank you, Madam Chair. I second this motion for approval.
All in favor of this motion? The motion carries. The application for item 41 for 74 and 78 Oak Ridge Drive has been approved, subject to conditions. Thank you.
There are no conditions.
Thank you.
There are no conditions. Sorry. Approved. We now move to item number 44, and that is 131 Bexhill Avenue. It's a consent application, and there are two minor variance applications. Yes, so two minor variance applications associated with this. So we have Leo Mastandria. Leo,
Yes, hi, good evening, everyone.
good evening. I'll just check if the resident is also online. George Morrison.
Yes, hello, good evening.
Good evening, George. Just stay with us for a moment. So Leo, over to you now. Would you like to make a presentation, or would you like to take questions?
No, I would like to make a presentation if you don't mind.
Sure, you have 5 minutes. Please go ahead.
Yes, so essentially we canvassed the area and we have submitted 56 support letters, including the two adjacent properties. The engineering and development has no concerns. The forestry department also has no concerns, but they have conditions. And community planning has no concerns with this application. If you could pull up page 2 of my presentation, Katrin. So this is our lot study, which this is a pocket just south of St. Clair with basically 5 streets running north-south, starting from Pharmacy, then Bexhill, Westbourne, Maybourne, and Pitt. There's 86 lots on those 5 streets, which have the same frontage and same lot area. There's 14 only on Bexhill itself. And on the map that you see in front of you, there's actually 2 right beside our property, 2 behind our property, and 10 on the map specifically. Based on the minor variances, I wanted to remove one of the variances, number 6 on both of the applications. I think we can comply, so I don't think that's required for both applications for the rear platform. And in speaking to the side yard setbacks, item number 1, So we do comply with the 0.9 on the neighboring properties. The variance requested is between our own properties. And as far as the number 2 and number 3 are the lot area and the lot frontage. I have in my submission, if you pull up, Katrine, the third page number 13, 17, 13, which are basically similar size consents that were approved here at the committee. Can you pull up my presentation package number 13?
Leo, just
Hello?
so you know, yes, we're pulling it up. Give more. Just so you know, you have 2.5 minutes left.
Yes. So if you pull up some of those decisions, you can see that we're consistent with what's been approved here at the committee. Variance number 4, the lot coverage, again, also there's decisions that are consistent with the built forum as well as what's been approved at the committee.
Sorry.
And variance 5. Hello?
Yeah, we're just trying to pull it up. Just bear with me for a second. Is this the one you're looking at?
Yeah, so that's the same size frontage and lot area. And this proposal is in keeping with the 4 tests of the Planning Act. And I feel that it's a great opportunity to create a new lot that will have no adverse effect in the neighborhood. And in addition, the proposed development will not will respect and reinforce the general physical patterns in the neighborhood. And if you have any questions.
Okay, all
also,
right.
if you look at page number 4 through to 11, these are all photos of lots that were split on Bexhill. So I believe it's consistent with what's been approved.
Okay. That's okay. The PDF is a little challenge right now. That's okay. Done?
Yeah, so page number 4 is 61 A and B Bexhill. Page number 5 is 59 A and B Bexhill.
Mm-hmm.
Page number 6 is 22 and 24 Bexhill. Page number 7 is 28 A and B Bexhill. Page number 8 is 32 A and B Bexhill. And also page number 9 is 68 A and B Bexhill. And number 10 is 142 A and B Bexhill. And right behind us, number 11 is 580 and 582 Pharmacy Ave.
Okay, Leo, your time's up. Just a closing remark because we need to move forward.
No, that's basically it. If you have any questions.
Sure, that's great. So members of the committee, any questions for Leo at this time? Member Taylor, please go ahead.
Yes, Madam Chair, through you. Leo, can you tell me what your intent or objective is in striking out variance 6 from your variances with respect to the deck?
I thought it was minor, and I didn't think we needed it. It's very minor. I can get rid of it.
Well, yeah, I'm thinking like it's neither here nor there. You're talking 3 square feet difference.
Yeah, it's.
I mean, I don't see any merit in.
No, I agree.
reducing it.
I agree, but I just thought by minimizing the variances might help the application.
Okay.
Thanks, Member Taylor. Any questions for Leo? Member McCauley.
Question for Leo. I'm dealing with the variances and your coverage. You're asking for 42% coverage versus 33 on 44B and 43% coverage versus, again, 33 on the second
Yes.
lot. which of the millions of lots that you have done and are showing to us have coverages of over 42%?
If Katrine, you can pull up page number 14.
Page 14 of your presentation.
Yes, page 14 of my submission.
Which is?
So page 14 is 67 Bexhill, and it's 43.6%
It's
approved.
Yeah, it's 1432 of the PDF.
Yeah, so if you pull up page
1432.
14,
1432. Go on, go on.
right, so this one's approved at 43.6%. Then you pull up page 17. 17 was approved at 68 Bexhill at 43%. If you pull up page number 20, 20 was approved at 43.63%. 444 Pharmacy. And page number 24 is 574 Pharmacy, approved at 45%. And the last one is page number 28, which was approved at 48.74%. And these are all within 500 meters of the subject property.
Okay,
And
thank you. You've made your point, and you've done your homework, which I appreciate. I think what I'm seeing here is that in this particular area of Bexhill, we're going to have maybe a couple more consent and variances because gradually that entire area is going to 7.71 meters of frontage in spite of the zoning bylaw. And the lot areas, in spite of the fact that they're established at 33%, are 42 or 43 or 45% coverage. That causes some concern because as a committee, we can only look at each application on its own merits. And what I see happening here is that the whole area is changing. At some point, I would assume community planning is going to be also turning their minds to whether these areas should have its own revisions rather than item by item, variance by variance, dealing with that area. But that's not part of what we've got tonight. All we're looking at are the merits of one consent and two lots, which are of having variances that are similar to other lots in the area.
Okay, at this time, I'm just going to
I have
say,
no further comments, Madam Chair.
okay, thank you. I'm cognizant of the time and I'm cognizant of the fact that there's a resident waiting to speak. So I'm going to turn it to George Morrison.
Hello.
Hi, George.
Okay. I'm going to give you a little thumbnail history of this block, this section of Bexhill, where there's a park which occupies half this block. Built by soldiers come from war. Two D-Day veterans lived on this block. There was another gentleman who was a survivor of Dieppe. Why is this relevant? Because each soldier who came home built in his own style through his own means. This twin cookie cutter style of home, I assume with a flat roof, although it's almost impossible to tell from the drawings I've received, correct me if I'm wrong, completely destroys the character of this block of housing and the legacy of those soldiers who built this neighborhood. Now, I feel I should also comment on some of his presentation where he displayed a number of consent applications to the committee, which were approved. But you needn't go that far. You needn't go to the bottom of Bexhill. You can go 4 doors down to 121, which you'll see in my written submission was much more modest a proposal, and it was turned down. It seems to me you don't have to go much further than that. As far as the 53 letters of approval that he submitted on form letters. People just didn't understand in some cases what they were signing. The person who also submitted a written letter of objection said, I wouldn't have signed it if I understood that's what it was about. You can say, well, that's their responsibility, but those letters were signed in January, before the signs went up, before there was any notification in this neighborhood that that's what he was talking about. So I'm going to rely on the written submission that I made for you to understand, and this little bit of color background that I've given you to make your decision on this application. I've lived here 70 years. I've watched that farmhouse sever the property that's under discussion. The farmhouse is next, the original farmhouse is next door. That, the property under discussion is going to be severed again, was only built in the 60s, in the early 60s. It's a fine house. It has a long history. I understand there has to be renewal in this neighborhood, but not complete redevelopment and not in the style that he brings onto this street or this section of Bexhill. Thank you very much.
Hello?
Oh, sorry. I gave the whole spiel and my mic was off. So, how would you like to respond to the concerns that were raised?
Well, I'm very sympathetic with the neighbor, but we did show the drawings to the neighbors. It actually says on the letter that I, name of the person living at the address, have reviewed the drawings for 131 Bexhill with the owner, and that they have no objection. So, along with the support letters, I prepared a package for the owners with the drawings as well. So they did see the drawings. And if you look at the character of the neighborhood, if you can pull up my page number 1 of my submission, or page number 2, sorry, page number 2 of my submission, right beside us, there's 25-foot lots on either side, and they were that was the built form. And there's 2 behind us. So just surrounding our area, there's 4 properties surrounding our area that has similar sized lots. If you pull up page number 2, Katrine, go back, yeah. Yeah, that one there. Second, the next one down.
You know the marquee?
So our property is hatched. It's in the middle of 2 25s, and behind it there's another 2 25s. So I believe that it does maintain the physical character of the neighborhood, and it is appropriate and does meet all 4 tests.
It's okay. Okay, so what you're showing there are lots of similar
Those are
character.
exactly the same size lots.
Okay, they're all
Mr.
separate.
Leo, could you read out the size of these lots, like the frontage and the lot area? I cannot.
The frontage is 7.52.
Mhm.
And the lot area is exactly
Yeah,
what we're asking
right
for
click.
at 240 square meters.
Right click. Right click, rotate clockwise.
Yeah, so the frontage is exactly what we're asking for, and so is the lot area. And those were that was the built form, because that's a corner lot, number 133.
Okay. Members say, does that help you and help answer your questions?
Yes, Madam Chair, I was just wondering about when Mr. Liu was talking about the character of the neighborhood. Of course, my concern is about the frontage proposed over here is 7.71, around 7.5 for both the lots. And when I go to the variance, the requirement is like it says the community planning say we need a frontage of 12 meter, while it would be only 7.71 at that point. So I was just making a comparison. What is the character of
Okay,
in the neighborhood? Thank
okay,
you.
got it. Just want to clarify, Mohammed, that it's not community planning who's asking for minimum required lot frontage. It's it's the city zoning bylaw that requires that. Okay, any further questions? Okay, I see none. We need to take the matter into committee. We have to deal with the, the three applications, and I believe there are also conditions. And before we go into the committee, I just want to make sure that Leo knows what the conditions are. Leo, you're aware of all the conditions, and do you have any questions regarding those conditions?
No, we're satisfactory with all those conditions.
Okay, all right. All right, we take the matter into committee. Committee members? Any thoughts? Member Taylor?
Yes, Madam Chair, first with respect to the consent, I'm satisfied with the proposed lot pattern. As was pointed out, it's identical to lots existing both north and south of the site. There's also a pair of identical lots to the east, I guess it is, fronting on a street. I don't know what its name is. Anyway, I'm satisfied the lot pattern is compatible with this immediate context, and I move approval of the consent subject to engineering and construction services conditions plus any standard conditions of consent. I find the variances to be minor in nature and meeting the other three tests under the Planning Act, and I move approval of both variance applications subject to urban forestry condition number 3 times 2. So that would be,
As amended, yes. So, Member Taylor,
okay, yes,
the
I
application's
will
amended.
agree as amended.
Thank you.
That would be my motion.
Okay, so
Through
basically,
through the chair, you may the committee may wish just to do all of these, impose all of the conditions on the consent application
yes,
as amended.
yes,
Okay.
yes. So the minor variance is being amended, not the consent. Okay, so the consent application was not amended. The conditions are associated with the consent application. The associated minor variance applications have been amended to remove variance number 6. Okay? And there are conditions of urban forestry, standard conditions of consent, and conditions of engineering services. So that's the motion on the floor. May I have a seconder? May I have a seconder, please? Okay, I'll try this. I will second this motion. All in favor of this motion? So Member Gary, Member Taylor in favor of this motion, all opposed. Member McCauley and Member Said are opposed. The motion's carried. The applications have been approved as amended and subject to the conditions as noted. Thank you very much.
Thank you. Have a great night.
Have a great night. And last but not the least, is it? No. God, no. We have more left. One more left? Okay. Item 45. 3517 St. Clair Avenue East. And we have with us, let me pull up, Jean Carlos. Are you with us, John? Oh, the agent and the owner is not there? Okay. Um, can you ask what's his interest?
We're here. We're
Oh.
here.
Stefan?
Yeah.
Yeah, I'm right here with John Carlos.
Oh, you're Jean Carlos. Okay, all right. Sorry, we didn't see
No,
your
no,
name. Okay.
it's me, Stefan, and John Carlos in the same room.
Okay, all right. Thank you very much. Just stay with us for a moment. Um,
Sure.
we just do a roll call here. Darren, Julice, neighbor in opposition. Okay, staff tells me they're not signed in. And then we have Mandissa Arlane.
I am here.
Okay, thank you, Mandissa. Just bear with us for a few more minutes. So now I'm going to turn to Jean Carlos. This is item 45 for 3517 St. Clair Avenue East. And it's a consent application. And there are two associated minor variance applications. So I'm going to request Jean Carlos to provide any comments or make a presentation, or does he want to go directly into the questions?
No, I wouldn't mind just giving you a brief presentation.
Sure, please go ahead. You have 5 minutes.
Okay. Thank you very much. First, I want to wish all of you a good evening. I want to thank you for your strength, your resolve, and your energy. I know it's been a long day, and I want to thank you. So this application, we worked hand in hand with the planning department here and transportation. We approached planning department to notify them of the plans, and they impressed upon us the importance of having a garage in both homes and no front pad parking. So in accommodating that, that triggered a number of what we feel are very minor variances. In fact, 5 of the variances being sought relate to height because of this garage. So that would be variance 5, 6, 7, 9, and 11. And they all speak to height in one way or another. The first is the height with respect to the building itself. We're asking for 10 meters as opposed to 9. And that is so we can have the minimum roof elevation for to have a peak roof, not a flat roof. If you look at the heights of the floors themselves, they're not, we're not asking for 11 and 12-foot ceilings. In fact, what we consider the basement is less than 8 feet at 7 foot 10. The first floor is 9 feet, and the second floor is 8 feet. Certainly pretty standard. Again, we're not asking for anything crazy or wild. That speaks to that. Because of the garage and where it's situated, this has put the what we consider the basement. The city is now considering the first floor and calling it a 3-story home. But in fact, it's not. It's a basement. We think it's a basement, and it's a technical variance insofar as that there is, I believe, more height above grade than below grade. And we have to do this because if you look at how the lot is situated, we're at the crest of the hill. We're right at the top of that hill, and that's caused us some issues. But again, we are not proposing anything that's not in the area. There's a pair of semis in the next block over. The identical variances, or virtually identical variances, have been approved to the lot right beside us at 3515. So I wanted to speak to the height. So the deck, which is another variance, because it's now, the city calls it the second floor, it's the first floor, right? And again, the front door entrance, we're allowed 1.2 meters. We're a little higher, again, to accommodate the garage. So there's 5 variances in total that relate to having a garage, which, again, the planning department impressed the importance of that upon us. Variances 13 and 14 relate to minimum size. So we understand that. We understand we're asking for, I mean, even though it's zoned RS, there are minimum size requirements. But again, I would point out to the committee that the lot right beside us had these same variances, these identical variances. With respect to coverage, yes, we acknowledge that. Length, we acknowledge that, but not, the length is in play in the upper level, what we call the second floor. It's not on the first floor or basement. So we think it was very straightforward. A number of these variances arose because of the nature or of the topography of the lot itself. We're not asking for anything that doesn't exist in the neighborhood. We're not asking for any side yard or rear yard or front yard variances. And considering the fact that there is a GO station less than a kilometer away and a subway station 1.3 kilometers away, we feel this is a pretty gentle form of intensification and is in line with the city's official plan.
And if I may summarize, we are asking for relief to zoning bylaws in order to build semi-detached type of dwelling that fits within the planning strategy of intensification and providing or supporting sustainably affordable housing options. We think that the proposed variances are minor in nature and are interrelated and are derived from the design decisions due to the requirements of semi-detached dwellings. We had previous experience with the identical shape immediately neighboring lot, which got approved at COA to sever the lot and build semi-detached dwelling. This was a corner lot and enjoyed a wider lot frontage and bigger lot area, but was still slightly less than minimum bylaws of 7.5 meters and 255 square meter lot area.
Okay, your time's up. So I guess we can move to the questions from the committee members now. Committee members, any questions for Stefan or Jean Carlos? Okay, I see none. Okay, thank you, Jean and Stefan. We will certainly get back to you, but let's see what we have to hear from the neighbors. So Darren, you mentioned Ali is not signed in. All right, Mandissa Arlene.
Hi everyone.
Hi.
Hi. So, thanks for allowing me to speak. It's more out of curiosity than and just a bit of concern. I am located adjacent to the property being developed, so I'm to the very south of it. So the project's backyard and patio will be facing my home. I'm a bit concerned that the new structure will block the light currently entering my home, and also curious about how it will affect my privacy. But also I have two questions that I'm not sure can be answered at this point, but I'll ask and see. In terms of construction noise, when is the project scheduled to start and end in terms of dates, and what times will the work start and end each day? That's it. Thank you.
Okay, so I thank you for your questions. But just want to know, do you have concerns with the consent or the minor variances?
No, I don't even understand those.
Okay, that was very honest of you. Really appreciate that. We are going to now move to the, before I do, members of the committee, any questions or comments for Mandissa? Okay, I see none. Okay, so hopefully, Mandissa, will get answers to your questions, and then maybe you will better understand at the end of the day what this application is about. We'll go to Jean Carlos or Stepan.
Thank you, Madam Chair. And I thank Mandissa for her concerns. The first one is the construction noise. There are municipal bylaws that govern when noise can be made, and they're 7 a.m. to 7 p.m. Monday to Friday. And I think it's like 9 to 5 on a Saturday. I'm not too sure about Saturday. We try not to work on the weekend to respect the neighbors. So as far as construction noise, that's how I can answer that. As far as blocking the light, I'm a bit puzzled at that because where we're located, she's behind us, and the rotation of the sun would favor the houses on Marsh as opposed to the houses on St. Clair. So I don't see any kind of light deprivation issue because the sun will be behind us and behind her home as well. As far as have I missed anything else? I don't believe I have.
No, I think you haven't missed any of her questions, and I guess basically, if you can just in a nutshell describe the two consents and that the minor variances associated. Just a very quick overview for her to understand it, if I may.
Oh, okay. Well, we're just very, very good. Thank you, Madam Chair. We're just severing the lot to create a pair of semi-detached homes. And in so doing and placing a garage in both those homes, this has triggered a number of what I would term more technical variances than substantive. We certainly believe they're minor, and that's why we're in front of the committee today. And again, because we wanted to avoid a flat roof, that triggered some height variances, as did the garage. So I would answer it that way, that they're relatively minor in nature and they won't impact the properties on Marsh Avenue at all.
Okay, I think that was helpful. Thank you very much, Stefan. Before I take the matter into committee members, any questions for Stepan and Don Carlos at this time? Member Macaulay. We can't hear you, Member Macaulay.
Can you hear me?
Yes.
It takes a minute for this to work. Okay. All right. Question to the applicant. You are proposing to build a semi-detached dwelling, correct? So that we're going to get two new dwellings fully attached on this lot. In this area, can you point out to me, and I'm looking particularly at the road plan on page 1553, can you point out to me where there is another similar semi-detached dwelling?
Yes, I can, Member Macaulay. 3533 and 3535 St. Clair. And then the lot immediately beside us, which it's our understanding it's been renumbered to 3513 and 3515 St. Clair.
Okay. All right. Thank you.
Okay, that's great. Thank you. Any more questions? Okay, I see none. All right, thank you, Jean and Stefan, for your time. We'll take the matter into committee now. Members of the committee, any thoughts or comments, or are you ready with a motion? So remember, when you're making a decision, you have to consider the three applications together: the consent and the two minor variances application. And we also have a forestry memo. I believe there were conditions of urban forestry. Okay. And then we have standard conditions of consent. And then we do not have any conditions from ECS. Right? Perfect. Member Macaulay.
Okay. I didn't even unmute myself, so you could presumably should be able to hear me.
Okay.
Dealing with the consent application to begin with, I recommend approval of the consent application to create lots with a frontage of 6.09 meters and an area of 209 meters. And that would result in one semi-detached dwelling of 2 units. And I'm specifying that because initially I was rather confused as to whether we had 2 semis or just one semi. One semi-detached, fully semi-detached dwelling. So I recommend approval of the consent applications. I believe it fits in with the character of what is happening in the area, which is why my question of where are there other semis in this particular area. And it provides for an appropriate development in the area. The consent applications would be subject to the standard conditions from development engineering and any forestry conditions. I'm not going to check to see whether there's a forestry report or not.
There are.
Probably is. So that's dealing with the
Hmm?
consent application. Do you want to deal with that first, or shall I move on to the variances?
Yeah. And standard
Member,
conditions.
see, there is a semi-detached on both the lots, like there are two semi-detached. You are mentioning only one of them?
No, there's two.
There's one to the east, and I think of this lot, and there's he mentioned one further over.
Okay, I
on
must
St. Clair
remind,
Avenue.
I must remind the members, we're in the middle of a motion here. We cannot discuss the application now, we're on the motion. Okay, so we have a motion on the floor to approve the application, subject to condition of urban forestry, standard conditions of consent.
I will continue the motion to put the reason for that motion is that there are semi-detached lots in the area. And so this is not a new proposal, nor is this a proposal that would undermine the development of lots on St. Clair Avenue.
Got it, okay, thank you. All right, so we heard the motion. May I have a seconder, please? I have a seconder? I don't have a second, so I will second the motion. All in favor of this motion? All opposed? Okay, so member Gary, member Said, and member Taylor oppose the motion. The motion is not carried, which means the application has been refused. Right? That's how it's going to read us? Oh.
Through the
Oh,
chair,
sorry,
you
yes.
need someone else needs to put another motion in
Okay, sorry, it's the end of the day.
or reword the motion.
Okay, so so the motion did not go through. Now I need a new motion. Member Taylor, you want to go ahead?
Yeah, Madam Chair, I'm quite sensitive about the immediate context here. The five buildings fronting onto St. Clair Avenue East between Cotton and Marsh. And the predominant building form along that little block of five houses is bungalows. So I don't see that bungalows on 12-meter lots line up nicely with tall semi-detached units on narrow lots. So I just don't think it's an appropriate consent application.
Okay, so can I?
So my motion would be to refuse the consent.
Oh, but okay, so do you realize the semis are permitted uses? They're permitted built form?
I'm aware of that, and
Okay.
I guess considering everything that we have to consider.
Okay, fair enough.
The fit with the context is another consideration. I know they're permitted by zoning, but I just don't think I don't think it's a good fit
Okay,
on that small section of street.
fair enough. So we have a motion to refuse the application for reasons as described. May I have a seconder, please? Member Said seconds the motion. All in favor of this motion? All opposed? Member Macaulay opposes it. The motion is carried. The application is refused. Okay. Thank you for your.
Through the chair, that motion was just on the committee of adjustment. Was that only on the consent application, or was it all on the all?
If the consent fails, then
That's
everything
true.
fails.
That's true. Okay, thank you.
Yeah, so the consent was denied, so all the other applications are redundant. Okay. So that brings us to the end of the agenda. Thank you everyone thank you all the committee members, and thank you all of you who had been tuned in since this morning. Thank you for your participation. Now, in terms of other business, I want to go to the agenda. What else do we have on the agenda?
Through the chair, I believe there's a reference to a TLAB hearings that the decisions of recent TLAB hearings, and for just getting it here.
Yeah, so basically there's for our information, 3 applications been appealed to the TLAB, and then you provided us with TLAB decisions in order for some previous ones. Okay,
That's correct.
okay. We didn't see it in the agenda. Do you mind forwarding it to us when you
I
get a
will.
chance?
I'll forward it to the committee members.
Thank you very much. All right, so this is only for information purposes. Date of next meeting is June 23rd. Can I have a motion to adjourn? No one wants to adjourn the meeting?
Should we go till midnight, or is that what we'd like to do?
Member Taylor, motion to adjourn.
I'll move adjournment.
Okay,
I'll
seconded
move
by,
adjournment.
thank you, seconded by Member McKay.
Thank you. You guys are at home. We're here. We're stuck here at City Hall. So thank you. Thank you for adjourning the meeting.
Thank you, guys. Appreciate it. Have a good night, everyone. Bye-bye.